YEKATERINA. All persons having anything to do with the honorable, the justices of the appeals court, now sitting at Boston with men for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
All right, good morning. And before you start your argument, let me introduce the panel to you and to everybody else in the courtroom. My name is Ariane Vuono. I'm joined today by Justice William Meade to my right and Justice Maureen Walsh to my left. A few quick reminders. Each side normally gets 15 minutes. That's going to be an exception in the first case that we hear. But normally 15 minutes. We've reviewed everything you've submitted to us very carefully, and so you can get right to your arguments. And there is no rebuttal in the appeals court in Massachusetts. So the exception, as I just mentioned, is this first case, which I'll call now Roskin Properties versus Boston Cars, Inc. and another. 2022-0713. This particular case has been paired with the following case, 2022-1257, because all the parties are the same and represented by the same attorneys as well. So instead of having you jump up and down twice, you're each going to argue only once, and you each have 20 minutes to make your argument. All right? Okay.
Thank you, Your Honor. Members of the panel, may it please the court, my name is Zach Kleinsasser from the law firm of Greenberg Traurig. With me is Amanda Carney. We represent the tenant, the appellants in these two appeals, CAREY International Inc., Boston Cars Inc., and CAREY Limousine Boston Inc. In the words of this court, the landlord has dragged the tenant through a costly and ultimately fruitless exercise. After 4 years of litigation on the eve of trial, landlord sought to dismiss both of the lawsuits that it brought against the tenant in this case. But because of the fee payment clause in the commercial lease between these two parties, landlord can't simply dismiss this case and wash its hands of it as if it never happened. The contractual fee payment clause in the party's commercial lease is mandatory. The prevailing party is entitled to recover its attorney's fees. And there is no question who is the prevailing party here. In the 2017 case, which is appeal number 1257.
There's a question. There sure is a question of who the prevailing party is. I mean, that's the bulk of the argument here, right? And on both cases, you lost that argument, right?
That's correct, Your Honor.
Okay. So that's a little bit much to say, there's no question, but we'll continue with this and say your argument, if I understand it right, is that whether dismissed with prejudice or dismissed without prejudice, you're the prevailing party, correct?
Correct, Your Honor.
Tell me why.
So the first reason is by looking at what the court in Barden has said about how we interpret a prevailing party provision. That's the first issue. We look to the lease and we look to what the court has said prevailing party means in a contractual fee payment clause. So the lease doesn't define prevailing party. It's not defined in there. So what we need to do is see what the common law is. Unfortunately, we have guidance on this issue. The court in the Barden v. Guyot case and a number of other cases has provided guidance as to how prevailing party is to be interpreted. And the court has said that the prevailing party should be interpreted in the ordinary and popular sense, and that the prevailing party must be given its common sense meaning. And so that's what we start with. We look at how is prevailing party ordinarily understood. And that was my point, Your Honors. There's no doubt in our view, as that term is ordinarily understood, as that term is commonly used, the tenant one. The second place we look
Before you go to second place to look, the language that we're talking about here that we're required to interpret does not finish with just the prevailing party shall be entitled to recover from the other party reasonable attorney's fees, but also says the amount which shall be fixed by the court and made part of the judgment or decree rendered.
Absolutely, Your Honor.
So that is language that is different than the case upon which you rely.
Correct, Your Honor. Now, a couple of points on that. So if we look at Section 25 of the lease, which is what you just quoted from, that's page 38 of the first volume of the record appendix, that language Well, the lease itself requires the court to do a couple of things. Number one, it needs to determine who's the prevailing party. So figure out who is the prevailing party. Number two, it needs to set in a reasonable amount of fees. So it needs to determine what's reasonable in terms of the fees. And number three, it needs to include that amount in a judgment or a decree. Now, what the trial court did, and what Landlord does in its briefs, and it has argued with the trial court, is to say that that provision at the end means that there needs to be a ruling on the merits, and that's not the case.
Well, let's just say we would agree with you on that.
Yep.
It does at least need to be part of a judgment or a decree, correct?
Correct.
So we have two different decisions from the trial court. One involving the 2017 case and one involving the 2021 case. In the 2021 case, would you agree that there was no judgment that was entered or decree rendered?
Well, there is a dismissal of the case.
Yeah, but
So
that's an order, right?
Correct, Your Honor. So what would need to happen?
Wait. I'm sorry if I paused. An order is not necessarily a judgment, right?
Correct.
So why is this order a judgment?
It's not. What it is an order, and then in the resulting judgment that needs to be issued or decree that needs to be issued, that would include the prevailing party's fee. What this is just, so in Barden, for example, okay?
No, before we get to Barden, which could be distinguishable, but is your position, so that I understand it, we have an order on the 2021 case. We yet to have a judgment.
Correct.
And your request then is that we reverse the decision and remand it and order the trial court judge to enter a judgment in your favor and then consider or address attorney's fees?
Partially correct, Your Honor. So in the judgment that would be issued by the trial court, that would include the reasonable fee award. So there would be it would be remanded back to the 2021 judge. There would be a hearing with respect to reasonable attorney's fees. Whatever that amount is would then be included in the judgment or decree that issues. And that is what the lease provides for. And that's what Barden does. Even though the language is different and doesn't include that provision about it being included in a judgment or decree, that's what happens. So if the final page of the case, when the appeals court is describing the dismissal, what it does is remand to the Superior Court for the entry of judgment in favor of Barden in reasonable amount as found by the court. And of course that's what it needs to do. It needs to send it back to the trial court so that it can determine the reasonable amount of fees, and then that gets put into a judgment or a decree.
So how is your argument different in the 2017 case in which, again, attorney's fees were not awarded, however, it was dismissed with prejudice?
The judgment of the court's order was incorrect, and our argument there is no question what courts have said with respect to a judgment of dismissal with prejudice. Very different than a 2021 case. We still think the lease controls. We still think Barden controls in 2021. But in 2017, we do have a judgment of dismissal with prejudice. That needs to go back to the trial court so that the trial court can determine reasonable fees, and then a decree would be issued with respect to the fee award. Now that issue, what has come up in Landlord's briefs as well as in the trial court is the issue of a ruling on the merits, and if I may just address that point briefly. This is the principal argument, as I said, relied on by the trial court and raised by the Landlord, and for the reasons we've explained, there does not need to be a ruling on the merits in order for the tenant to be a prevailing party. The first place to look is the unambiguous terms of the lease. The provision we just looked at doesn't include anything about their requiring a merits resolution, nothing about there being a resolution on the merits. Those words are not there. This is a contract that was agreed to by the parties. They could have defined prevailing parties differently, as they defined a number of terms in the contract. They did not, and so we look to the common law. And so what does the common law say? And this is the Barden case. The court here said in reversing the Superior Court, it said that a defendant securing a dismissal of an action is not a prevailing party under the contractual fee payment clause there, unless the dismissal on the merits, and the court says that's wrong. It says, the clause herein gives no hint of such a limitation. It is plain spoken. And that's what we have here. We have a prevailing party provision that has no hint of a requirement for an adjudication on the merits. Now, the critical issue with respect to the 2017 case is that we do have a dismissal with judgment that is an adjudication on the merits. And that's, again, different than the 2021 action. The plain language of the lease, again, makes clear that nothing is required on that, but the U.S. Supreme Court, the SJC, countless other courts have said, when you have a judgment of dismissal with prejudice, that is an adjudication on the merits. That alone is an adjudication on the merits. And the issue is the same if it's a voluntary dismissal or an involuntary dismissal. We've cited these cases in our brief as well. That is a judgment on the merits.
Let me ask you a question. The answer to which will not mean that you are waiving anything whatsoever, okay? It's a question. Could it be consistent in your view if we were to determine that the judgment of dismissal in the 2017 case needs to be reversed, but that the order in the 2021 case need not? Primarily because there's an issue of prejudice on one and no prejudice on the other. Could that be a consistent ruling in your view? Again, not giving up anything, because I know you'd rather have both. But
Thank you, Your Honor. We would argue for both. We think the lease and Barden controls both. However, it is a much more compelling argument in the 2017 case. We have a judgment with dismissal. There is no question. Courts have said that is an adjudication on the merits. Again, the adjudication on the merits is not required. That's not required by the lease. But to the extent it is,
But in the
we have that.
2021 case, not only do you not have the prejudice, and you also have the argument made by the judge that that case could potentially be revived, whether or not you think that that's not successful, but because of the manner in which it proceeded, it could potentially be revived. And it was, of course, dismissed, the motion was filed for dismissal before an answer or summary judgment had been filed.
Correct.
Both different than the other one. So they are potentially distinguishable.
Procedurally, they are distinguishable. I agree, Your Honor. With respect
Why
to
do we have 41A1 and 41A2 if there wasn't a distinguishing feature between the two? I mean, in your analysis, if I'm to accept it, you're the prevailing party in both, and it doesn't matter whether it was dismissed with or without prejudice. But there's a reason why 41A1 takes such great care to delineate before that. It's to encourage plaintiffs who are stepping into something that they want to put the backup lights on and get out to do so. And it's a right? And later, they may bring it back, they may revive it, but it seems to me that if we were to accept your argument, then there would be no differentiation between Rule 41A1 and 41A2, and I think there is.
I respectfully disagree. I think there is a difference, and here's why. What we're asking for doesn't contravene the policy of Rule 41. Rule 41 gives the plaintiff an opportunity to dismiss its case, to realize it either has a lawsuit that doesn't have merit or to decide it wants to pull back its case before the defendant expends a bunch of fees. What we're doing does not contradict that. Landlord still has the right to do that under Rule 41A1. The difference here is we have a contract where the parties agreed that the prevailing party achieves its fees. It can still dismiss its case. It's not spending money going forward. It has the right to drop its lawsuit, but there are real-world consequences because of the contract it signs. That's the difference here.
Okay, so in your scenario under 41A1, if the landlord backs out, you get attorney's fees, right? And then 3 months later, the landlord found the expert, was able to have the money to proceed to trial, and comes away the winner. Then you're the prevailing party on the first action?
We would be. That's right. We would.
How does that even make sense?
Because the lease doesn't provide for a single piece of litigation. It says any time there's a dispute, anytime the provisions of the lease are sought to be enforced or interpreted, that could be 2 lawsuits, it could be 3. So we could be a prevailing party on one, we could be a non-prevailing party on another. There's no reason we can't.
But we're talking the same lawsuit, right? We're not talking about, well, one's a slip and fall and one is an assault and battery or something, right? We're talking about one theory of recovery, it's backed up, it's gone, it gets refiled, and landlord comes away the winner. Right? Judgment enters for the landlord. If I'm to accept your analysis, that first action, you would be the prevailing party. And I'm trying to understand how
That's
that-
correct, because that's an effort to enforce the terms of the lease. We have prevailed in that action. If then there's a new action and the landlord prevails, the landlord would be at the prevailing party. Let me just also say that that is not possible here, because what we have is a dismissal with prejudice in the 2017 case. That 2021 case cannot be revived. We have a victory there. That case cannot, it's the same parties, the same lease, the same issues. For the trial court to say that that case can be revived is not accurate. That case cannot be brought again. There is a preclusion based on the 2017 case as the 2021 case. Significantly, landlord, with respect to the 2017 case, doesn't cite any cases and really doesn't even respond to the with prejudice argument. There's really no response. I anticipate that what the panel will hear is a number of excuses and a number of reasons why that case was dismissed. The panel will hear about how one of landlord's lawyers got sick, how one of the experts suffered a stroke, even though the other expert did testify to deposition and submitted disclosures. We'll hear about how the landlord saved the court and the parties' money and time, even though we went through 4 years of litigation and extensive discovery. None of those reasons are relevant to the determination as to prevailing party. Even if those are compelling reasons, there are a lot of reasons someone could dismiss a lawsuit or
You
not.
argue the opposite in your brief, don't you? I mean, you basically argue the landlord sandbagged you, calling into question his intent and waiting and not responding and never telling and waiting until the very last minute to kind of pull the plug on this lawsuit. So it's either not relevant, the subjective intent of why a case is being dismissed either isn't relevant or it isn't, right?
So the reason we explain that is to respond to landlord's arguments with respect to the reasons for dismissal. We felt like that was important to address and correct the record on those points. But I agree, it is an objective standard. Those reasons don't matter. What happened as to why it took longer than it should have, or the landlord's reasons why it decided to drop the case, those are irrelevant. What matters is what the lease says and what Massachusetts law says, not the reasons for dismissal.
The federal court, at least one federal court, treats it differently, right? As far as voluntary dismissal and whether, even under a contract, attorney's fees must be awarded if there are reasons that would justify dismissal.
I'm unfamiliar with that case. Landlord didn't cite any of those cases, cited no cases that talk about, as far as I'm aware, that discuss the reasons of those. And again, what I would go back to is Barden, where this court made very clear that it's long been held that a voluntary discontinuance or dismissal by the plaintiff or a non-suit or dismissal, so voluntary or not, that party is the prevailing party. That's what this court has ruled. And that controls in both the 2017 and the 2021 case.
Did you want to make any comments in the remaining of your time with respect to your brother's arguments that he's brought in his cross appeal?
Just briefly, Your Honor, we think those should both be affirmed. On the sanctions issue, I think it's very clear in the record what happened leading up to the sanctions award. The judge, in her discretion, recognized what had happened and issued a sanction award with respect to that. The supplemental complaint issue, that again, as I think we've explained, was an end run. The 2021 case was an end run around that ruling. That ruling was correct. There were no new facts that were brought, and so the judge correctly ruled under 15D that there were no new facts that allowed that case, that claim to go forward.
On the issue of sanctions, what's your argument that it was before the wrong judge. I mean, in essence, the landlord was trying to have the motion for sanctions reconsidered because of a belief that the judge relied upon a particular factor that they said, no, that's not accurate. And a different judge of the Superior Court ultimately ruled upon that motion. What's your position on that?
We have no issue with that, and Landlord didn't either below. And we cite a number of examples where Landlord made that very argument. You know, Your Honor, even though you're a different judge, you can hear this issue. And repeatedly made that point. We don't have any problem with that. It is true that another judge can reconsider another judge's issue. That, you know, it could have gone to Judge Fournier, it didn't, and there's no issue with that. There's no problem. So that's Landlord's argument. We disagree with it.
Any questions? Thank you very much.
Members of the panel, may it please the court. My name is Arthur Goldsmith. I represent the appellee and cross-appellant ROCSAM Properties Limited. This paired appeal requires this court to interpret Section 25 of the March 10th, 2000 lease, with a 10-year lease, not initially signed by my client, because my client didn't purchase, ROCSAM didn't purchase a property until 2007. But nonetheless, the lease is binding, and in fact, the original tenant, CAREY Limousine, was succeeded to by Boston Cars, all of whom are subsidiaries of CAREY International, which is a non-party to the lease. Nonetheless, they want to recover their attorney's fees because they are fronting the costs, or at least that is our suspicion. And when
It doesn't really matter, does it?
no, it doesn't.
Okay.
Here's the issue. When you interpret Section 25, and Section 25 is different in language than the Barton case, and particularly in the Barton case, on page 778, it refers to as the party in whose judgment the case enters. Now, the Barton case, which was distinguished by Judge Connolly in the 2011 and 21 case in her January 6th decision, she distinguishes it. But even more importantly, it doesn't apply because there was no judgment in this case. But in our opinion, or at least Roxanne's opinion, Barton,
There was a judgment in the 2017 case.
yes, what happened was,
Well, we know what happened, but you would agree there was a judgment that entered, a judgment of dismissal with
Yes, the
prejudice
judgment of
in the
dismissal
2017 case.
entered. When the case came up for a pretrial conference, and Attorney Wardwell submitted his affidavit, and we announced abandonment of both the 2021 case, which we filed under 41A, with our voluntary notice of dismissal. That we had the right to file as a course.
I'm inquiring about the 2017 case. I heard you say that there
We
was
then
no...
filed, the Roxanne filed a detailed motion to dismiss under 41A2 because the case, they had filed answers and everything. So we had to explain why we were dismissing our
I
case.
understand that. Bottom line is you agree that a judgment was rendered in that case.
Of course, and that was entered on September 9th. When the case came up for argument before Judge Donatel, she said, well, should we just dismiss the case? And I said, look, and the only issue about prejudice versus non-prejudice, which was the 21 case, which Judge Connolly referred to, is that we said, look, we're not going to relitigate this case. You can dismiss it with prejudice. That doesn't trigger their entitlement to attorney's fees. That doesn't trigger their being enable them to
Well,
be a
it
prevailing
does
party.
if we were to interpret the, it does if we were to agree that CAREY is the prevailing party, and that and if we were to interpret the phrase in the lease agreement as saying that what also is required is a judgment or decree.
Right, but when you read Section 25, in order to be entitled to attorney's fees or to even be deemed a prevailing party, the party has to have brought an action in breach of the lease, which we brought. CAREY did not bring it, but they didn't even file a declaratory action or a counterclaim for attorney's fees to enforce or interpret. They did not file any action to...
And where do you find any authority for that to be a requirement?
Because it says in Section 25, in any action or to, and it says in breach of a lease or to enforce or interpret any provision or covenant of the lease. They didn't bring any action to interpret or enforce the lease. What they're saying is, and they could have done it, they could have filed an amendment to their answer, or as we did in the 21 case, a form of declaratory answer. Are we entitled to fees for merely defending against a claim? They didn't file a counterclaim.
Under that analysis, landlord wins or wins with attorney's fees. Tenant loses or wins with no attorney's fees.
Well, one could interpret Section 25 as saying it's not applying to a mere defense of a lawsuit in the absence of some form of enforcement action. In the Bank Thermo case, there was no Rule 8 counterclaim or claim for attorney's fees, which they did not bring either.
So if respectfully we disagree with that analysis.
All right. Now let me get on to
where do we go from here?
Here's where we go. When the original case, and here's where our cross appeal arises. They filed a motion, CAREY filed a motion to compel an inspection. They were granted an order on April 22, 2019 to conduct an inspection by April 29th. April 29th happened to be the end of the discovery. They could not conduct the inspection by that date. So what did? They filed a motion to amend the order to allow an inspection on the 8th, 9th, or 10th of May, which the court granted. But
what they did is they went to you and said, give me a day or two.
No, they immediately filed their answer on the same day.
Because you wouldn't agree to it, so they had to go to court to get an
We never
emergency
disagreed with it, Your Honor. Attorney Wardwell never disagreed with it. And in fact, if you read his opposition to their motion to modify the answer, Wardwell even says, and it appears on page appendix 323, 324, modified the dates, Your Honor. So the order came down modifying, he says it, we don't disagree with a modified date. Modify the dates. The judge enters an order.
Up for a moment. We're here on appeal.
Yes.
Justice Frenier allowed the motion for attorney's fees as a sanction.
Right.
Justice Donatello agreed.
Justice Donatello agreed only.
And we've read the transcripts as far as parties going before the court and asking to be heard.
Right after Judge Frenier entered her order for the $7,016 in sanctions, ROCSAM filed a motion to stay in accordance with the TD video decision, which says you should stay in order. Plus, ROCSAM didn't want to run afoul of it. And we combined within that motion to stay a motion for relief. The judge thought that ROCSAM had opposed the inspection. ROCSAM had not imposed the inspection, had not disagreed or didn't allow for a modification of the inspection.
My point is that you went before Judge Donatello and argued the merits of the case.
You read Judge Donatello's August 31 opinion, all she does is says, I've read Judge Frenier's decision and I'm repeating it. She didn't do an independent analysis of our claim. When you decide a motion on reconsideration, and just when we filed the motion was filed under not just 9A, because it was a motion to stay, which was required under the TD video. It went before Judge Caprolani. He said it's a motion for reconsideration, and under 9D, all those motions go before the judge who entered it. We had no problems with that. It never got before Judge Frenier. It just didn't. I mean, and then when the case came back for ultimate decision-making, we decided to dispose of the case. And the Bannister case says, Bannister versus Commonwealth, which we cite, that when the case came up for final judgment, a judge may vacate a sanction order when entering a final judgment. But the May The inspection took place on a date outside the court-ordered dates of 8, 9, and 10 of May. How did it take place that day? Because Attorney Ward will agree to that. He offered the 10th, he offered the 13th, the 14th, the 15th. If you read his...
So to cut to the chase, your point is that when Judge Donatelli did not reviewed your motion to reconsider the order granting the sanctions, it was not done thoroughly. It was not a motion to reconsider, and that's why there's an abuse of discretion there. Is that correct?
That's correct, Your Honor.
Okay. And you're no longer arguing, or maybe you are, that the motion should have been heard by Judge Frenier in the first place.
Well, what happened was...
I know what happened. The question is whether or not...
We didn't care whether it was heard by Judge Frenier, but Judge Cipriani said it should be heard by...
We know the record. We know the record. My question is, on appeal, are you still arguing that the motion to reconsider should have been heard by Judge Frenier?
Because Judge Donatello expressed reluctance to overturn a sister judge.
So is the answer yes, or is the answer no?
Well, the answer is yes, but it should, but even notwithstanding that, she did not independently review the merits of our motion.
I see that. You have two, you're arguing...
We were arguing, one, the sanctions were improperly entered, and they were improperly we were not relieved of them, because one, you can't sanction a party for simply not agreeing to a date. That the Warren case and the Griziana case said you can't sanction a party because they disagreed with them. But in fact, ROCSAM did not. How did the inspection take place?
I understand. And so your point is that when the judge reviewed this, it wasn't with an eye towards an actual true reconsideration. It was just, I'm going to...
But she did not.
All right.
And in fact, her decision shows that all she did was repeat it. And I think what happened was Judge Frenier got bombarded with a ton of papers by the CAREY International...
We don't need to speculate as to what happened. In any event, it went before the judge, and when it did go before the judge, you did not object. Judge Donatello.
No, no.
Okay.
But when she expressed reluctance, then she should have, in accordance with Judge Cannon, the case came before Judge Cannon on September 9th of the previous year, and she says, oh, I can't handle this case, it should go before Judge Frenier again. She reordered the case to be re-argued or the motion set down. And with respect to why it came before Judge Donatello, in fact, there was a few other judges who came and went in the case. The party doesn't mark up motions under 9A anymore. We don't know what...
You keep seeming to go back, and this is why I was trying to find out. Is it correct that you are not arguing that it was error for this case, for that motion to be heard by Judge Donatello rather than Judge Frenier?
It was not error, but she erred in not independently reviewing the merits.
Not that. We've already established that. That's your argument.
Any judge should have said, look, the sanctions should not have been entered in the first place. ROCSAM did not oppose the inspection. It was our property that was the subject of the lawsuit.
Okay.
We extended the time. There was no violation of any court order by ROCSAM that would have warranted sanctions. There was no misconduct.
Can we turn to your claim about the motion to amend and
Sure.
the error there?
Here.
I understand what your argument in the past was, but then you dismiss the action. So let's just say that you're go ahead.
All right.
If you're right.
Here's what happened.
No, we know what happened.
Well, it became...
We've read the record, counsel.
We filed...
Let me just rephrase the question. If we agree with you, listen to the question, if we agree with you that the motion to amend should have been allowed, what's the remedy?
Well, it goes back to the context of why ROCSAM filed the 21 lawsuit.
What's the remedy?
We're not going to retry the case, Your Honor, but...
What's the remedy you're asking for? I want to draft an opinion, and I'm drafting it. Roxanne is correct. The motion to amend should have been allowed.
If the motion to amend had been allowed, there would have been no 21 case, and all we were seeking by the amendment was not a new cause of action. It was just to assert a form of restoration damages because ROCSAM had just been allowed
What is the remedy? I'm finishing my
We're not going to
sentence
bring a
here.
new lawsuit, but
You wouldn't have had to file the 2021 lawsuit, is that what I just heard you say?
I'm sorry.
Your
no?
answer is that you would not have had to file the 2021
correct.
lawsuit?
And we would not have had to file the 21 lawsuit.
Which you voluntarily dismissed. So where's the harm?
Where's the harm in denying the motion? Because it required us to, once we had that denial, which was entered usually at the same time the Judge Halal set a trial date, although it was filed, we drafted that, it was filed during the COVID period, when trial had been continued, trial had not been set, trial was not set, was not imminent, and we weren't seeking a new cause of action. What we're arguing is that ultimately, ROCSAM had Attorney Wardwell not become ill and not been able to try the case. We would have had, if our new expert was allowed to testify, because he was the one who came up with the restoration measure of damages versus the repair measure, he might have been allowed to, the judge might have been allowed him to testify under the CAS, K-A-C-E case, Leon case, which all we tried to do was give the other side advance notice that we were seeking a different form of measure of damages. Not necessarily more money, just a little different form of measure, restoration versus repair. And 8 months later, trial, even when the COVID period had ended, case may not have been tried, but ROCSAM made the prudent decision, which we explained in our motion to dismiss the 17 case, which Judge Donatell accepted Attorney Wardwell's
Back
reasons.
to Judge Walsh's question, there really isn't no remedy that you're seeking because you dismissed the case.
It's the same kind of, right, but insofar as letting the court know that had that motion not been denied, is what caused ROCSAM to file the subsequent independent
The
action,
2021 motion.
which we sought to consolidate, but ultimately none of those motions were heard because ROCSAM abandoned its action. The 21 voluntarily.
Wasn't the motion to consolidate denied?
No, never acted on because the case came up for pretrial on April 13th of 21, and we abandoned both actions. In fact, what motion did CAREY win in this case to be considered a prevailing party? Nothing. In fact, the only motion that they may have won was a submission for attorney's fees. When the judge...
Well, didn't a complaint seek about $500,000 worth of damages?
Did the complaint? Well, no.
The original complaint filed in this case?
No, but one of the experts' opinion, the restoration expert opinion, said that it could approach that for restoring the premises.
What was the amount of damages that was alleged in the by Roskin in the 2017 case?
I don't have that in my brain, but I know that the amended complaint the amended complaint and also...
Well, it would have been some amount, upwards of...
$500,000 was an attachment to our motion to dismiss, showing what the second expert, because our first expert had a double stroke, would have calculated the restoration measure of
So when you
damages.
asked the question, how did they prevail, when you dismissed the case,
Right.
they were no longer on the alleged hook for about potentially $500,000.
Right, but insofar as prevailing, what we're arguing is that a party doesn't prevail by being the recipient of voluntary action. One, the 21 case voluntarily dismissed under 41A1, and the second action, we filed our own motion to dismiss, explaining the reasons as Rule 7 requires. Attorney Wardwell becoming too ill, questions about the expert, and my client decided, look, we'll abandon both actions, and now we have to defend off because they interpret Section 25 to mean, so long as we prevailed by not being obligated to pay $500,000 or any amount.
Well, can I ask you this question? Had you not filed that motion in the 2017, right, and you went to trial, and at the end of trial, the tenant wins, would they be entitled to attorney's fees?
Well, when you say if the tenant wins...
A judgment in their favor.
Judgment in favor of the tenant.
Well, if you read...
Under the contract, would they be entitled to reasonable attorney's fees?
If you, without having brought a counterclaim for enforcement or interpretation of the lease, potentially no. In fact, Judge Donatel in her September 8th decision says that she would be disinclined to have awarded fees or costs against ROCSAM based on her interpretation of the Section 25, which Judge Connolly also interprets as well. And therefore, their remedy is we go back before Judge Donatel and says, I already said I was disinclined to award fees or costs. And of course, the rule, their offer of judgments don't apply because the judgment didn't enter against us and in their favor under the Delta case, is that she's already said she wasn't going to award them costs. We made a prudent decision. The court agreed with all the reasons we set forth. We felt obligated to make that presentation. You had a turn, and under Rule 7, expressing your reasons why. But there is no motion that they won in this case other than the wrongful assessment of sanctions against my client. Thank you, Your Honor.
Thank you both very much for your arguments. All right. The next case is, I'm going to need some help with pronunciation of the names in this case, or the name of the plaintiff, rather. YEKATERINA MERKULOVA versus LDJ Development, 2022-1224. Okay. We're ready to go?
Good morning, members of the panel. May it please the court, my name is Attorney David Fry, and I represent the appellants, Premier Property Solutions, LLC, and LDJ Development, LLC. Your Honor, as outlined in my brief and the accompanying materials, it's the appellant's position that the lower court made an error in law in sort of two factors that I think are important. One is the interpretation of the terms of the rental application, and the second is whether or not there was a formation of a contract in the form of a lease agreement between the parties. It's the appellant's position that there was an error in law and potentially an abuse of discretion in finding that neither of those documents created a contract. And I'll go through each of them.
When you say lease agreement,
Yes.
what are you talking about? No agreement was actually signed, correct?
That is correct.
Okay.
There was not any actually signed lease agreement. But
So what we're really talking about is what the ramifications of the rental application.
I think both are important, but I can start with the rental application, and I can also explain why I think that the negotiations around the lease agreement may have formed a contract between the parties. The lease application itself has a provision that I think is important for the court to note, and that is that the deposit amount may be kept as damages by the owner in the event that there is a breach of the terms of that rental application. And when the applicant submits that deposit amount, it is potentially something that can be retained as damages once that applicant has been accepted by the owner and once a lease agreement has in fact been proffered for their signature.
It doesn't require for the lease to actually be signed, just proffered is sufficient as far as you're concerned?
So the language of the lease application does say if their application is accepted. And at the juncture where the lease was actually offered to the sales agent in this particular instance, in my client's view, that is what triggers the potential for them to be able to keep that application amount, to keep that first month's rent deposit, as is the case here, if in fact the applicant then refuses to engage further in the transaction. So in this case,
It's one of the fees that's covered by the statute, I mean, Section 15B of Chapter 186.
I think it is.
Which one is it?
So in this particular case, the landlord requested a first month's rent deposit. And I don't think there's any dispute between the parties that that was what it was intended to be. They were not requesting the other deposits until there might be an actually fully executed lease. So in this instance, the landlord requested a first month's rent deposit as part of the application. The application was accepted, and the reason I say that is because the landlord's agent presented a lease, a standard Greater Boston Real Estate Board lease for potential signature. After that point, there were actually additional negotiations between the parties, but I want to focus first on the landlord application or the tenant application.
But as Justice Vuono said, she didn't sign a lease.
That is correct.
So how does that become a first month's rent as opposed to this deposit, as it was also called?
I think that the parties did intend it to be first month's rent. There's communications between my client's agent and the salesperson who was representing Ms. Merkulova at the time. And that salesperson asked what is needed in order to apply for this apartment, and she was told that a first month's rent, along with a standard landlord tenant application, would need to be submitted. And so the parties intended for that to be a first month's rent for the potential lease.
But it doesn't say that anywhere in writing, right?
No, it is in writing, Judge.
They intended it to be first month's rent.
It is what was requested by.
No, does the writing say the parties agree this will be first month's rent?
On the application itself?
Yes or no, does the document say that it was intended as first month's rent?
Not on the document itself, Judge. There are written communications between my client's agent and the agent for Ms. Merkulova saying that that was what was being requested as part of the rental application. So there is writings between the parties saying that that's what it was for. In terms of the lease agreement, it's my client's position that there was a fully formed contract. I understand that the document was not signed by all the parties. However, there were extensive...
Are you referring to the rental agreement or the lease agreement when you say there was a fully formed contract?
I'm referring to the lease agreement.
That was unsigned?
It was not signed. That's correct. But
I'm sorry, I thought earlier, and I'm just reviewing my notes from when you started, you agreed that there was no lease agreement.
Well, I agree that there was no fully signed lease agreement, not that there was never one negotiated.
If it's not signed, how is it a lease?
Well, let me explain that, if I may. The parties had extensive negotiations between each other after the rental application was submitted. The applicant had asked for certain changes to the lease agreement to be made.
The locks and the furniture, et cetera, et cetera.
Correct.
Right.
And
Well,
those,
we're familiar with those facts.
and it's our view that each of those requests was essentially a counteroffer to the original terms of the lease agreement, which the landlord accepted by saying that they fully intended to have those terms included, and in fact they did add those terms to the lease agreement. And thereafter, Ms. Long, who was the agent for the applicant, indicated that she believed that her client would be signing the lease that day or the next day.
Let me ask you this.
Yes.
If your client decided not to rent the premises and not sign the lease, clearly the money would have been returned. Is that right?
It would have been, but I think that would be.
If you decide not to go through with it for whatever reason, the money would have been returned. Now, let's say we hypothetically were to agree with you to a certain extent, which is that the rental application required the prospective tenant to provide the first month's rent, which could only then, under the rental application agreement in hypothetical terms here, would have been required for the prospective tenant to give you that money. You could have only kept it thereafter if there were some sort of damages, right? If you didn't suffer any damages, you also would have had to return it.
So, and we do allege that there were damages that were suffered.
If there were no damages, hypothetically speaking, the money would have been returned.
I agree with Your Honor,
Okay.
yes. And in this case, my client was unable to secure new tenants within a timely fashion to actually mitigate those damages.
Are you saying also now that it's undisputed that your client incurred those damages?
I don't know if that's necessarily a disputed issue.
Well, it would have to be undisputed in order for you to prevail on summary judgment, right?
Correct. And part of my appeal also involves the fact that the lower court did not really make findings on whether or not.
Well, the lower court would not make findings before the judge was cross motions for summary judgment.
Right. And so there weren't specific findings on our arguments concerning our counterclaim for damages because the court viewed those as being red herrings. They didn't really address them with any specific findings, but it was our position in our counterclaim that the landlord was damaged in the form of lost rent. They had to lower the rental amount to find and encourage additional applicants.
I understand your allegations, but I just was trying to find out whether or not, in your view, those allegations of damages are agreed upon or undisputed for purposes of summary judgment, or were they not?
I don't know if they were undisputed.
All right, I'll be asking your sister as well.
I would like to potentially hope so, but I can't speak for the other side. They may find that they want to say that those are disputed damages. But just getting back to your question about whether or not that deposit would be refundable at the point that the landlord is not damaged, you're correct. And that's what the landlord tenant application says. It says that the money can only be applied to actual damages incurred. And in this case, the landlord lost out on the rental income that was due for the very month after the application itself. I want to just touch briefly on.
Can I just make sure that I'm clear?
Yes.
Is your argument that both the rental application is a binding contract and the unsigned lease agreement is a binding contract?
Yes, I'm making both arguments. I do think that, to be fair, that the stronger argument is that the landlord-tenant application is a contract. It is a less strong argument that the lease agreement unassigned could be considered a contract. However, one of my counterclaims in the lower court was of detrimental reliance as well as misrepresentation of kinds, because the applicant had applied for multiple apartments at once, withdrew, or I put that's from their perspective, withdrew the application as soon as they had secured a new apartment. These were all simultaneous applications. And so even if it's not a fully formed contract in the form of the lease agreement, it's our position that the lower court did not explore the potential for a detrimental reliance argument. Again, they classified it as red herrings and just said that that's
So how does the rental agreement, or application, I should say, how does the rental application become a binding contract? Isn't its very essence the preliminary step just to start the process?
Well, it becomes a contract because there's consideration, which is the deposit that was put down by the tenant. They also signed the rental application and then submitted it to the landlord for consideration. And it has the terms that deal with what could happen if the application is accepted and if a lease agreement is actually presented to that person for signature.
Right.
And just briefly, I want to point the panel to one of the CMRs that is cited by appellees, but I think it applies equally to the landlord. This is 940 CMR 3.17, and it says it shall be an unfair and deceptive practice for an owner to retain as damages for the failure of a prospective tenant to enter into a written rental agreement after signing a rental application any amount which exceeds the damages to which he is entitled under the law, or an amount which the parties have otherwise agreed as to the amount of the damages. So the context of that CMR is that we can't do anything that violates the security deposit statute, which I'm sure is going to come up in counter-argument. So the landlord cannot request more than 1 month's rent for each rental deposit, first, last, and security. But here we actually have a written contract that says that the deposit can be applied to damages, and there's nothing to say that the landlord is not entitled under the law to receive the benefit of that landlord application and apply the deposit to their damages, which is the
Now you're
loss of
calling
rent.
it a deposit. Is it a deposit or first month's rent?
It's a first month's rent, and that can be a kind of deposit. It's an amount that a prospective tenant pays before the inception of the tenancy.
Right, after a lease is signed.
It's not always after a lease is signed. Sometimes deposits are collected from prospective tenants, and I think that the CMR actually makes it clear that that's a possibility because it states that we cannot retain as damages for the failure of a prospective tenant to enter into a written rental agreement after signing a rental application, not after signing a lease. So I think there is a provision there that can give the court some guidance.
Okay. Well, I see your time is up. I'm going to inquire of the panel if there's any additional questions. No. Thank you very much.
Thank you, Your Honor. Thank you, Your Honors.
Good morning, Your Honor. May it please the court. My name is Lynn Wang, and I represent plaintiff appellant YEKATERINA MERKULOVA. GLC 186, Section 15B, regulates the types of payments that a landlord...
If you keep yourself a couple inches away from that microphone, we'll hear you a little bit more clearly. Thank you.
Thank you. GLC 186, Section 15B, regulates the types of payments a landlord may take from a prospective tenant at or prior to the commencement of a tenancy. Section 15B is clear that only 4 types of pre-rental deposits are permissible: first month's rent, last month's rent, security deposit not to exceed 1 month of rent, and the cost of a replacement lock and key. The rental contract that Ms. Merkulova signed made no indication that the whole deposit that she was to pay would be non-refundable. It was taken as first month's rent, but it was also communicated that it was to reserve the apartment. And defendant appellants also argue in their motions for summary judgment that it was a hold deposit, and such deposit is also not allowed under Section 15B. To the extent that it is considered first month's rent is paid as in contemplation and in exchange for possession. There was no possession in this case. There was no signed agreement. Ms. Merkulova never submitted the remaining money that was required, nor did she ever move in. And there is nothing in Section 15B that allows first month's rent to be applied as damages for anything. Section 15B does contemplate that the security deposit may be applied as damages, but it outlines what that may be applied for.
Let's say hypothetically we agree with you, and of course the judge below made that exact conclusion. The rental application does say that that money can be used to offset or to pay for the damages incurred by the landlord. If in your view there were damages that were actually sustained here, according to the rental application, that money could be used to offset those damages.
Under Section 15B and under the Attorney General regulations, it is not permitted for a penalty clause to exist that does not conform with
So
Section...
your view would be that that particular clause just has to be struck out because it's unlawful, and that's all there is to it?
So I believe the trial court read the rental application in conformity with Section 15B and interpreted that section to refer to a security deposit that could be applied to actual damages by the owner, but those actual damages would again have to be in conformity with Section 15B, and they would have to, be applied to the permissible items outlined in Section B as damages.
Okay.
To the extent that Section 15B is unambiguous and does not allow for damages to be taken in this instance, and also to the extent that there was no rental contract, there was no signed lease agreement, on May 14th, defendant appellant's agent stated, once we have the lease back, once we have the signed lease back and the remaining monies are paid, that is when we will begin to take the furniture out of the apartment, we'll begin to clean the unit, we'll replace the key. The agent set the terms of acceptance. There was just no meeting of the minds as to whether or not there was a rental agreement. There was no meeting of the minds that a lease or a tenancy had begun at that point, because the agent very clearly communicated what was needed for the next step. And what was needed was a signed lease. What was needed was the additional monies. And those steps were never taken. Ms. Merkulova's understanding was always that in order for a tenancy to begin, she did need to sign this lease, but she did not. And because of that, this first month's rent that was taken, which we argue was an impermissible hold deposit, should have been returned to her. And for those reasons, we would ask that the trial court affirm the trial judges, or sorry, that the appellate court affirm the trial court's decision.
Any questions? The panel has no further questions.
Thank you, Your Honor.
Thank you. We have one more.
Take a break.
I don't think there's a split. I think you're not, excuse me, but there was not a split representation here, right? So you've finished. The argument's over.
Not on my sheet.
Yep, I think the argument is over. I think you rested on your brief.
Yes.
Yes, okay, great. All right, thanks. Actually, the panel is going to take a very short recess right now, then we'll hear the last two cases. Thank you very much.
All right, please. Be seated.
Thank you. The next case we'll hear is Octavius Rowe versus the Boston Fire Department, number 2022-0928.
May it please the court, my name is Robert Johnson, and I represent Mr. Octavius Rowe, who's sitting here. This is a case that has come up from the Superior Court after a hearing before the Commission. And there are a number of key issues that are raised in the appeal. One is that the conclusion of the Commission and the Court, conclusions were not supported by substantial evidence. That's the one. Another point is that my client was deprived of his right to freedom of speech, freedom of association, free exercise of religion. We also argued that the factors that the fire department used, they were arbitrary, capricious, and abuse of discretion, and it was error for the court and for the Commission to not rule in Mr. Rowe's favor as a result. Also, we raised the argument that there was a motion to correct the record, and there was a motion for reconsideration so that the evidence relating to disparate treatment could be a part of the record. And we felt that that was very important after the decision of Brookline versus Alston. The issues that we raise grow out of Supreme Court, United States Supreme Court jurisprudence, as well as jurisprudence coming out of the Supreme Judicial Court. The leading decision on the Supreme Court case is Pickering versus Board of Education. And in that case, the Supreme Court said that when you have an issue of speech, there must be a balance of the interests of the employee as a citizen in commenting upon matters of public concern. And then once that is established, then the burden shifts to the employer to show that the interests of the state as employer in promoting the efficiency of the public service it performs through its employees. So there are two basic...
The commission agreed that the postings and the speech was on matters of public concern, but you didn't really address the second part of the test.
That's right.
How the department or the commission determined that how it affected the operation of their business.
Right. Yes, Your Honor. The court and the commission both admitted that he was speaking on matters of public concern.
We're good there. But part two, I don't see that addressed in your brief.
Well, all right. The court and the commission made very general conclusions that were not based upon facts on that second issue. It's our position that this failure for the fire department and for the court and for the commission to address the second issue is fatal to their case, that they failed to meet their burden. And as we will argue this morning, this is particularly important when we're talking about content-based intrusions upon First Amendment rights, because the burden is very high. Of course, and I have the citations here. Snyder versus Phelps, which is a United States Supreme Court case that was decided in 2011. Also, the SJC decisions would be Pereira versus Commissioner of Social Services, Town of Brookline versus Alston, Barron versus Colenda. That was a recent decision decided in 2023. So, our argument is the following, that because that second tier, the second tier of them, the fire department, setting forth an interest of the state in promoting the efficiency of public services it performs through its employees, they failed miserably in that burden. Now, why do I say that, or why do we say that in our brief? First of all, the evidence is overwhelming, substantial evidence that Mr. Rowe was an excellent firefighter. There was no evidence. There was 2 captains who testified that he was an excellent firefighter. There was a lieutenant who testified that he was an...
But this is all, the commission made determinations of fact based on the evidence that it heard. And if it chose not to credit the evidence that supported what you're telling us, then it's not before us. For substantial evidence, you have to show that no reasonable thinking person would have based their conclusion on what was before him that they credited.
That's right.
You list all the good things that Mr. Rowe has done for himself and the community, but you don't even cite a case on substantial evidence in your argument on substantial evidence.
Well, I beg to disagree with the court. I mean, we cited Pickering.
Excuse me, but 16 to 21, there's not a single citation to a case.
Well, there's Pickering versus Board of Education.
Substantial evidence, sir.
No, if we look at Pickering, Pickering will, and also a Town of Brookline versus Gerald Alston. There's discussion about this issue. The point I'm making is that we look at substantial evidence. What is the substantial evidence? The substantial evidence is that Mr. Rowe was an excellent firefighter. And that comes from 2 captains, a lieutenant, and another fellow firefighter. There was also evidence that his work in the community was important. And that goes right to the heart of this whole question of public, speaking out on matters of public concern. There was testimony of 4 community members who said that his work was substantial and important to them. So there was no evidence, there was no rebuttal of that evidence by the fire department, none whatsoever. So that evidence stands as unrefuted, okay? And we presented substantial evidence to support the fact that the fire department could not show that there was a relationship between his what he didn't do or what he did do affected in a negative way his work as a firefighter. There was no evidence of that. There was no evidence, there was no nexus. That's the word I'm looking for.
Let me interrupt for a moment. When you serve as a police officer or a firefighter, for example, in those instances where you are a public servant wearing a uniform representing a department, and they have those codes of conduct, my question, I guess, would be, is there more to just being able to put out a fire? Is there a more expansive view of what it means to represent the community, the entire community, not just a particular race, gender preference, etc.? And so the evidence that was before them certainly tends to be at least in contradiction to a view that when an individual puts on that uniform, their job isn't simply just to put out the fire. Bigger than that. And so by expressing this type of speech and opinions, it detracts from that position, from that ability to do their job. Their job isn't just so narrow in its construction?
Well, I would call the court's attention to Snyder versus Phelps. And in that, the United States Supreme Court said, speech on matters of public concern is at the heart of the First Amendment protection. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. I think the case law is overwhelming, both on the federal level and on the state level, that government should not monitor or delve into the content of speech. That speech is, the First Amendment right of speech is a very high obligation that government needs to respect. And the court in Phelps also said that the court is obligated to make an independent examination of the whole record in order to make sure that the judgment does not constitute a forbidden intrusion on the field of free expression. The court goes on to say it is necessary to evaluate all the circumstances of the speech, including what was said, where it was said, and how it was said. Now, on that point, in the facts of this case, there were 149 postings. Of the 149 postings, only 4 were done while he was on duty. The 145 postings were done on his free time.
And what difference does that make? If the postings were such that they contravened the code of conduct, does it make a difference if they were made at the time when somebody is on the clock, so to speak, or not?
Yes, it does. Because the closer it is...
Why is that?
Okay. Because the closer it is to the work or a nexus, if you could establish a nexus between the speech and work, the closer you get to the work, then it's more egregious. They have a greater right to monitor it.
And the issue whether or not the public knows who the person is and how that person is employed or not employed?
Well, there was no substantial evidence that of these 149 postings that the employer or the public knew about this. He published these things basically
He
with...
identified himself as a Boston firefighter.
Not in every case. They were made, out of 149, maybe 4 times, there was some indication that he was a firefighter. The rest of the times, he was on his own. He ran 2 programs, this Know Thyself program, Straight Black Pride program. He funded these programs himself. There was no money coming from the city. And actually, the city acknowledged in one of their memorandums from Connie Wong that no public resources were used.
Do you agree that the city can regulate off-duty conduct by its officers?
Depends on what the conduct is. If the conduct is speech, then they have they have no right, actually.
That's my question.
Okay. Yeah,
None whatsoever?
Yes.
Hate speech can be tolerated, et cetera?
Yes, hate speech is protected. It's protected speech. The court does not get into, that's why the court has taken the position. Okay, here's another quote from Phelps. Now, this one is from, Snyder versus Phelps. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. Okay? And it goes even further. If government is inquiring into the content of the speech, then it's pretty much a clear violation. And you could find that actually in Pereira versus Commissioner of Social Services, Supreme Judicial Court case, where the court said, the less the speech has to do with government, the less justification government has to regulate it. So the furthest you get away from this connection, this nexus between the speech and government, the less opportunity or right the government has to get involved in it. So in this case, 149 postings, 4 were done on duty. And then in Article 16 of the Massachusetts Declaration of Rights, it states that, quote, "The right of free speech shall not be abridged." And, all right, but let's look at the case of Town versus Brookline versus Gerald Alston, because that's a recent case in 2021 from the SJC.
You're going to have to sum up what it is you want to say about the case, because you're over your time now.
Oh, I see. All right. Under basic merit principles, according to this decision, the court was required to assure fair treatment. So what we've argued is that there was no fair treatment in terms of how Mr. Rowe was treated, that there were white firefighters who used the nigger word and they were not terminated. There were white firefighters who got convicted of drunk driving twice and they were not terminated. Whereas my client has the protection of the First Amendment and of Article 16 of the Declaration of Rights, and he was terminated.
Okay. All right. See if the panel has any questions. I see none, so thank you very much for your argument.
Good morning, Your Honors.
Good morning. Just
I
to
think
check,
it's still
Attorney
morning.
Hodge, you're going
my
to,
name is-
it's still morning. You're going to be arguing for 10 minutes, is that correct? 10 minutes, you can, thank you.
Yes, ma'am. May it please the Court, my name is Kay Hodge, and with my colleague John Simon, we represent the Boston Fire Department in this matter. And I would like to just start by addressing very precisely the issues that you raised with my brother about the prongs of the First Amendment. In this case, although I might personally take issue with the assumption that it was a matter, that the manner of the appellant's speech was a matter of, quote, public concern, it was assumed by both the Civil Service Commission and the Superior Court. So they essentially embraced what I think Attorney Johnson is asking you to do, which is to consider it protected speech unless. And then you've got to look at the interests of the city and what the fire department's interests would be. And ultimately, what Pickering and Garcetti and Lane and all of the issues or all of the cases ask the court to do is to do a balancing. And I've got to say, if you read the Civil Service decision, it's quite clear that what they found as a matter of fact was that the nature of the types of statements that were made here were of a particularly pernicious quality. And it was hateful, and they use a whole variety of words, bigoted, etc. Now, then you get to whether or not the city was able to establish that there was a showing documenting whether or not there was a problem. And the city did provide, or the fire department did provide, a variety of different examples. And I would direct the court to the listing of, if you will, examples that are at page 43 of our brief. They include a number of items in the supplemental appendix. I need to say just that this is a 30A appeal. You know that 30A is controlled by 30A Section 14, and the fact of the matter is that what we have is the unique circumstance in which the original appendix prepared by Attorney Johnson had not a single civil service document in it. And so the reason there is a supplemental appendix of some moment and length is that those are all the civil service decision and all of the transcripts and the other pieces of evidence. And so what you have in our brief at page 43, and this is 43 of the addenda, we're supposed to number them or our argument in the brief, is that we did make in a variety of different examples, and they're listed in our brief. Why is that important? It is important because the very cases that, in some respects, I think that Attorney Johnson cites, in particular Pereira, support what happened in this case. If there is evidence, in this case, it was clear evidence that the public and individuals were upset by what happened and what kinds of statements were being posted by then firefighter Rowe. Now, the question that he's raising is, well, was it enough? This was protected speech. I think that the answer, and the First Circuit has addressed that particular issue in the Curran case, and that is cited specifically again at page 43. An employer need not show an actual adverse effect in order to terminate an employee under their Garcetti-Pickering test. Garcetti itself refers to speech that has some potential to affect the public employer's operations. An employer need not allow events to unfold to the extent that the disruption of the office and the destruction of working relationship is manifest before taking action. And they cite there the Koenig case, a Supreme Court decision. Then they go on and cite in Waters, the court stated that it has consistently given greater deference to the government predictions of harm used to justify restrictions of employee speech than to predictions of harm used to justify restrictions on the public at large. Few of the examples we have discussed involve tangible, present interference with the agency's operation. The danger in them is mostly speculative, but they nevertheless find that it is sufficient. Let's talk about Cousins for a minute. Cousins was a situation in which the First Circuit was faced with the termination of a correction officer for an off-duty post, analogizing the management and tactics of the of Mr. Cousins' African-American boss to Adolf Hitler and his alleged motto, have no pity, act bullying, after a previous anti-Semitic letter for which he had been suspended. That was sufficient to uphold the termination. Attorney Johnson cites the Pereira case. The Pereira case is fascinating. It is the Supreme Judicial Court holding that the fact that a investigator of the Department of Social Services, who was also a politician, who gave an off-color racial joke at a breakfast, could be terminated by the Department of Social Services. And in that particular case, the SJC said, yes. Why? Because it affected the efficiency and effectiveness of the ability of the Department of Social Services to maintain the trust. Now, what are the findings of the Civil Service Commission here? The Civil Service Commission finds that, yes, it is sufficient, that the evidence presented by the Boston Fire Department was not only sufficient, it goes on to point out that the vile nature of the comments would undermine the trust of the public, in particular because it's firefighters, even though Mr. Rowe might be great at putting out a fire. The fact of the matter is remember, it is the fire service that also responds to emergency calls and others and enter people's homes. He would be entering the homes of people he attacked and vilified in his writings and in his statements. Now let's talk for a minute about substantial evidence. The evidence in this case was agreed to by firefighter Rowe. He took a yellow marker. The Civil Service Commission asked him to only, out of that 144, mark off everything that you wrote yourself or you said. And he did. And they are litanized in the Civil Service decision at paragraph 29, I believe, 26 or 29. But the fact of the matter is that they are vile. They're hateful. They indicate incredible degree of disdain for citizens of the city of Boston. Quite frankly, they they are the citizens that firefighter Rowe was expected to serve, and he did not. And for those reasons, I suggest to you that that all of the, shall we say, First Amendment argument should be rejected. The religion argument is really nothing more than the speech argument. It's really collapsed. He just says, I believe these things sincerely. He can hold whatever sincere beliefs he has. He just can't publish them and say to the world, this is how I feel, but I'm nevertheless going to come into your house and I'm going to save you, LGBTQ plus person, and you have to trust that I will do that. I don't believe that that's the way it works, and I believe the evidence supports the position of the Civil Service Commission. In addition, the nexus that he was a good employee is he cites 2 of his supervisors who said he was good. He was good. The problem is that doesn't necessarily mean he gets to engage in misconduct. Just because you may type very well does not mean that you get to engage in other kinds of conduct that is prohibited by your employer's reasonable rules. And the finding of the Civil Service Commission was clear that it was a violation of the rules. And in fact, it is the admitted conduct of firefighter Rowe that was the violation. Let us also talk about disparate treatment. Remember, the disparate treatment involves 3 individuals. J.C. immediately was brought up on charges and he resigned before the disciplinary hearing. M.D. brought up on charges, resigned before the hearing. Now, M.G., who is the 3rd person, denied that he had used the quote N-word, and despite all of efforts, it could not be discerned whether he in fact had used those words. And the Civil Service Commission, although it ordered the Boston Fire Department to look into that issue under Section 79, it did not. It made very, very clear that its order was completely separate and distinct, that the termination of firefighter Rowe was supported by just cause, and that the punishment of termination was appropriate.
Okay.
And with that, I thank you.
Good afternoon, Your Honors. Samuel Ferring for the Civil Service Commission. I'd just like to briefly recap what the Commission actually found in its findings. It held by a preponderance of the evidence that there was just cause for the termination of the plaintiff by the Boston Fire Department because he was guilty of substantial misconduct which adversely affected the public interest. And the nature of that misconduct was the posting of multiple comments in social media and podcasts, which the Commission found adversely affected the public interest by undermining the Boston Fire Department's ability to serve all residents of Boston, regardless of their race, religion, or sexual orientation. And I'm quoting here from the Commission's findings. Keeping Mr. Rowe as a Boston firefighter would force Boston residents to allow a bigot into their homes in order to receive emergency services, an unacceptable outcome that is not consistent with the civil service law or good conscience.
We're not reviewing the Commission's decision, though. We're reviewing the Superior Court judge's decision.
Yes, Your Honor, but I believe the Superior Court upheld the decision of the Civil Service Commission, which is why we are here. And in that case, again, as my sister adverted to, what the Commission did, as it was required to do, was apply the law, which in a First Amendment defense of this case involves a balancing test of weighing the rights of the plaintiff to speak freely versus the interest of the public agency to operate efficiently and effectively. And here, in particular, the fact that the public agency was a first responder enhanced the importance of maintaining discipline and maintaining a proper image to the public so that they can go ahead and carry out their mission. And I find it extremely compelling that in this hearing, the plaintiff did not utter any of the statements which are at issue here. And the reason I suspect that he did not, and that I will not, is because they are so hateful and so viscerally repulsive that to say them in public would evoke a very, very negative reaction. And that is exactly what the department was faced with. What is the public going to think about the Boston Fire Department if it chooses to retain an individual in its employment who espouses these kinds of views in this manner? And it came to the conclusion that it could not continue with his employment because of the effect that it would have on the effectiveness of the Boston Fire Department. There's a plethora of law that supports that decision, in particular with respect to the considerations that have to be taken into account by a first responder paramilitary type organization. I have yet to see a case in which the degree of misconduct was as egregious as it was here. In Pereira, for example, it was a single incident that led to the firing of the individual. In Pickering, I believe is very close to that as well. Here we have incident after incident after incident. And so you have to look not just at the conduct itself, but the degree of misconduct. So here you have a combination of both extremely hostile statements repeated over and over and over again, and statements which have come to the attention of the public and have begun the inevitable process of public reaction to this. And the department had to react to that, and that's what they did. And I should point out, they weren't required to wait until someone complained. The law is very clear that the department is entitled to evaluate the conduct and determine whether there is a risk of that happening. Here, that risk had already manifested. So there was no consider, and the fact that it was, again, off-duty, in Pereira, the comment was off-duty. There are multiple cases where off-duty conduct can trigger this kind of behavior, and the rules of the Boston Fire Department for conduct unbecoming and social media posting also apply to off-duty conduct. So I want to again reiterate the comments of my sister here, and unless the court has any other questions, I would respectfully request that the Superior Court judgment be upheld.
No, there's no rebuttal in the appeals court. I'm sorry. The case will be taken under advisement. Thank you very much. Okay, we're now ready to hear the last case on our list for this morning. IRENE Tabachnick versus CT Install America, number 2023-0014.
Good afternoon. May it please the court. David Summer for CT Install America, LLC. Your Honors, CT Install America moves to reverse the finding of the Superior Court for several issues. I know the court's aware of the facts. This case arose from a contract whereby CT Install agreed to install some windows in exchange for $15,000. At trial, the plaintiffs in this case asserted that there was an oral modification of the contract whereby CT Install America agreed to take on the repair of some pre-existing structural issues.
Wasn't the actual modification have to do with CT agreeing to put in the new windows, the longer windows, and fix the so-called slant in the wall in doing so, right?
Well, right.
That was the modification.
Well, no.
The slant.
Well, the slant is the pre-existing structural issues that were...
Well, there was even more than that afterwards, wasn't there?
That's correct. But with regard to
With regard to the oral modification, it's CT Install's assertion that we don't even get there because in this particular case, there was no consideration provided for CT Install to take on any additional work beyond the installation of the what was originally contracted for, which was the installation of the windows for $15,000. And I referred the court to the testimony of...
So you agree that there was evidence from which the judge could find, by preponderance of the evidence, that there was a offer or a statement, we'll take care of this, we'll fix the slant and put in the longer windows?
Well, I will agree with this. Certainly, Ms. Tabachnick testified that that there was an agent of CT Install that did say those statements that you're mentioning.
Okay. In other words, so there was a basis for the judge's decision, or the answer to the special verdict questions, which is what we're really talking about.
Well, there was certainly facts whereby Ms. Tabachnick testified that an agent of CT Install did make those statements. But I don't think that we get there, Your Honor, because in this particular case, what she also testified to, and this is on volume 2, page 69 of the appendix, she testified that there was no mention at all as far as money with respect to this additional work. And that's really the crux of the issue. When you have an oral modification of a contract, you do need to have some consideration. And in this case, there was absolutely no consideration discussed at all. And this is blatantly admitted to by the plaintiff herself. I know.
Isn't the testimony the admission that there was no discussion of money with the CT representative as to what was going to be entailed, but that she knew there was going to be money involved, and in fact, then hired the very same subcontractor that CT had contracted with at her house for $2,000 to look into how to fix the wall?
No, I believe that the testimony was that she hired the subcontractor to remove the flooring. I don't think...
Just determine how the wall was going to be fixed.
Right, but CT Install received no consideration for that. That was a separate agreement that Ms. Tabachnick entered into with the subcontractor. That doesn't in any way bind CT Install. CT Install never indicated that, or never indicated that, or never asked Ms. Tabachnick to engage their subcontractor to remove the flooring. That was a separate agreement that she entered into with the subcontractor, Mr. Nolette. And in any case, the $2,000 that she paid Mr. Nolette is not in any way, shape, or form consideration with respect to CT Install. There was no evidence provided at trial that CT Install received any consideration at all for the alleged oral modification of the contract. Now, with respect to the issue concerning negligence, there was no causal connection between CT Install's action and the complaint about harm. The Superior Court in this case awarded the Tabachnicks various damages for reconstruction of the den for $50,000, $15,000 for installation of a structural beam, $5,000 for the return of the deposit, $2,000 for the flooring, which it paid Mr. Nolette, and about over $3,000 for an architect and design. Presuming for a second that CT Install was negligent in what it did, in no way does the redesign of a room or an installation of a structural beam caused by anything that CT Install did. Presuming they installed improper windows and the like, nothing that they did caused was the but-for cause of the Tabachnicks deciding to tear down their den and rebuild it, or the installation of a structural beam.
Wasn't there evidence that they had no choice, that once your client decided not to reorder the windows and put in smaller windows, so nothing would happen, presumably nothing would have ever happened, everything would have been still to code, the house would have stayed the same, the house was built in the 1950s, and it would have retained its original character had your client agreed to put in the smaller windows. Instead, once your client said, nope, we do this all the time, we'll put in the windows that you want, that you originally liked, because we can fix this problem. Didn't everything cascade after that?
I respectfully, Your Honor, I disagree with that. I don't think there was any evidence that things cascaded. These were things that happened before. So in other words, if you allow the verdict to stand, essentially what the court would be doing is putting the Tabachnicks in a better place than what they would have been before CT and Stahl entered onto the scene, and that's not...
You didn't allege anything like unjust enrichment or anything like that, right? That they were getting more than they should have gotten with respect to all of their improvements that they did in their house.
I'm sorry, Your Honor.
Well, you didn't make that argument at trial, did you? That given their allegations that you were responsible for all of this, all of these renovations as a result of the original alleged negligence, there wasn't any argument on your part that, well, there's a point of no return. We're only responsible for X amount, and to allege or to actually award the plaintiffs more than that.
Well, I think there was argument that CT and Stahl was not responsible for pre-existing issues, and I think that's the natural progression with respect to an argument suggesting that it would put them in a better place that they would have been, and that's of course the hard and fast rule regarding negligence or any compensatory damages. You have to put the plaintiff in the same place that they would have been. This applies both under the negligence theory and under the contract theory. Compensatory damages puts a person in the same place that they would have been before the purported harm happened. And in this case, what the Superior Court did was they said, we're going to give you a brand new room, we're going to give you a new beam, all caused allegedly by them putting in the wrong windows. And I want to make one point with respect to the arguments that you're making, and I would refer...
I'm not making any arguments, I'm just asking questions.
Sorry, the questions
Don't get the wrong impression.
The questions that you're asking. If you look at and this was one of the exhibits to the trial, and I think it's at Record Appendix Volume 3, page 165. The plaintiffs in this case actually got the windows replaced, and they got it replaced by a company, and this was one of the exhibits that they presented at the trial. And that's what the court should have used with respect to determining damages, this $22,700 bill. If you look at that evidence, nowhere does it say on that estimate that there was some requirement to rebuild an entire room and to put structural beams in to repair the purported damage done with these improper windows. So that alone is completely contradictory to what the plaintiffs were saying at trial, which was, oh, we had to do all these things. There was this cascading effect whereby we couldn't do anything because we had to do all these other things. It's clear by their own evidence that they didn't have to do those things because part of their evidence was they could have repaired the windows for $22,500
And then repaired the floor, because the floor had been partially demolished as a result of allegedly relying on the opinion of this, your client's representative that the longer windows could be put in and the slant could be fixed.
Well, Your Honor, I also do point, I mean, there's no, I point out in my reply brief, there was never a claim for any sort of reliance claim here. There was only a breach of contract negligence in 93A.
Right, that's fair. I'm just trying to figure out where you would stop. So your view is that really the only damages incurred here was replacement windows. And I suspect also like fixing the molding that went around or things like that. But that's where the buck stops, so to speak, as far as you're concerned.
Right. I mean, this would create, I mean, a slip, you know, you go down this slippery slope, right, where someone says, okay, you say I have this $15,000 contract to replace my windows. I'm going to get a whole new room, put new beams in, all these other things. I mean, I suggest it was error for the Superior Court to go down that road. It should have been looking, presuming that, I don't think, as I stated earlier, that there was an oral modification of the contract because of the lack of consideration. But even if you went down that road, the court has to focus on the compensatory damages here. And it didn't do that. Instead, it just allowed all of the damages, which did not in any way flow from the $15,000 window project. Just a couple of points. I know I'm running out of time here. With regard to the 93A, the 93A, I would suggest to the, I mean, obviously it's within my brief, but at most, I would suggest this is a breach of contract and 93A was improper here. I just want to move on because I know I'm running out of time. With respect to the indemnification issue, in this case, CT Install sought indemnification from Mr. Nolette pursuant to a contractual agreement, and the Superior Court found that CT Install was not, could not get indemnification from Mr. Nolette. I would suggest to the court that's erroneous. The Superior Court did not find the contractual indemnification clause was void under the statute, which I think that is correct. And if it didn't find that it was void under the statute, that's Chapter 149, Section 29C, it should have found that there was indemnification here because all of these, Mr. Nolette was the individual that was performing the work, and CT Install was only performing the work via Mr. Nolette. So in that particular instance, because the Tabachnicks were claiming that the work performed was negligent and the like, Mr. Nolette should have been on the hook for indemnification for CT Install.
Okay.
Thank you, Your Honors.
Thank you very much.
Good afternoon, Your Honors. John Harkavy, representing the appellees, the Tabachnicks. This case shows the importance of 142A and 93A in protecting homeowners against unscrupulous conduct of certain home repair companies who take advantage of homeowners. CT Install misled the Tabachnicks into thinking that they had hired a company that had its own crew of factory-trained employees who would do the work. In fact, CT Install hired untrained subcontractors who passed themselves off as CT Install employees. When an issue with regard to the slanted wall in the den came up, Mrs. Tabachnick alerted CT Install and said, you have to reorder these windows, they won't fit. Mr. Donadio, the general manager of CT Install, said, look, it's our mistake, we do it all the time. And when it became apparent, when the remedy was too expensive, CT Install left the job and said, we're not going to be doing it anymore. The damages incurred by the Tabachniks, whether in contract, negligence, or 93A, all were a natural consequence. Or
Why don't the damages stop after they had the windows replaced and walls patched and the floor that had been only partially demolished repaired?
It doesn't stop there because, based upon the word of Mr. Donadio, that they were going to remedy the situation. Mr. Donadio told Mr. Nolet to work it out with Mrs. Tabachnick to remove the floor. And once that was done, then they discovered the serious structural defects. And as you pointed out, and what my brother in his brief and his argument here today ignores the fact that no work would have had to have been done, there would have been no underlying structural code issues if Mr. Donadio CT Install had just installed the windows and they reordered windows that would have been fit. None of the other damages would have been had. And that's the but for, the negligence of Mr. Donadio in saying that that's our mistake, we can do it, you handle that. With Mr. Nolet to remove the stone flooring and the cement.
So your point is that once that happened, the inspector would not have permitted it just to be sort of covered up and redone because now this other structural defect had been revealed.
Absolutely. And
Was it just that it was revealed, or would it have still been, in other words, let's say it had been revealed for other reasons? Was it something that needed to be remediated, or it could have, it had the stone floor stayed there originally, and not been changed, there would have been no structural problems?
There would have been no structural problems because the floor would not have been taken apart. What happened was that once the
once the floor was taken up, they could see the cement. When the cement was taken out, they could see the joists were not properly.
I'm sorry,
there.
I'm just having trouble hearing. I guess I'm getting
I
old.
I apologize. No, yes, once the floor was taken up, then they realized the cement had to be taken away, and once that happened, they saw that there was a problem with all the joists underneath. Correct, but that problem was already there.
That became a problem once the floor and the cement were removed. They found certain structural problems, and in order to fix that, you had to do certain remedial work. That remedial work would never have had to have happened if they just installed windows that fit into the existing framework. And my brother talks about consideration. Let me just highlight that. First of all, the case that he cited in his brief with regard to consideration, the graphic arts finishers case, that case, a company agreed to move based upon a promise that if they moved, their moving costs would be covered by the Boston Redevelopment Authority. So that tenant incurred moving costs with somebody else, and the court found that that was the consideration for the promise to move. So they, just like my client, hired Mr. Nolet for $2,000, and that was consideration for the promise to rebuild the wall.
As I recall, the evidence that was done with the knowledge of CT, right? In other words, they knew that Mr. Nolet was going to be doing that work.
Absolutely.
Yeah.
And in fact, Mr. Donadio told Mr. Nolet to work it out with the Tabachniks. And once again, my client, they thought these people were CT employees. So they thought that was all, if Donadio's telling them, work it out with an employee. And so she was willing to pay that $2,000 to have it done. And then once everything hit the fan, CT bailed on the entire project, and they had no choice but to refinish the wall. My brother talks about consideration. In a footnote, he talks about this being a UCC case, and he says that there's no oral modification. The lack of that, even in the UCC, there is no consideration needed to amend a contract under the UCC, and that's in his addendum. With regard to lack of consideration, it's not in the answer as an affirmative defense. It's not in the pretrial. It's not in the request for rulings of law. It's not in the motion for judgment for dismissal, and it wasn't done at oral argument. It's raised for the first time in the brief, and I think that argument is waived. And even if it's not waived, there was consideration. One of the issues that, first of all, it was a $16,000 contract. How did I get to the, a $70,000 judgment?
76, yeah.
$76,000 judgment. There is a slight difference. As I pointed out in my brief, it could be explained for $400. There's a $400 difference. If the court were to say, well, let's reduce it by $400, I would understand that. But the damages, the large damages, were all consequential damages of Donatio's statement and the actions taken. As Donatio said, Nolet will be there. He'll install the windows. And Fran Panicelli, the person who measured the windows, he's going to be reframing the wall. My client thought this was all happening. With regard to 93A, there was no initial permit for the windows. When they did get a permit, they never told the court, the building inspector they were doing this work. They told them that they were doing replacement windows, not new construction windows. And they were completely, and the town inspector came in and said, none of this work is any good. So, and with regard to measure of damages with contracts, I took it upon myself to say my client would have had to put in windows anyway. Mm-hmm. So the contract for $22,000 versus $16,000, I didn't even want to get into the betterment issue. I took that off the table. So usually with a breach of contract, it's the cost to repair less the unpaid balance. But in my case, we didn't get any benefit out of any of that work. It's not like with a usual housing project, someone puts in half the stuff and you don't have to redo everything. And then my client was not bettered, so I didn't ask for $22,000 because then they would have been in a better position. I didn't even ask for the 22 or the full contract amount of the replacement windows. So it's not about a betterment. Does the court have anything else?
You've answered my questions. No additional questions. Thank you.
Thank you.
Good afternoon, Your Honors. If it pleases the court, Andrew Kuchar on behalf of Jerry Nolet, doing business as Nolet Construction. During the arguments that were just presented, nothing really came up except for the floor in which my client was contracted with the Tabachnicks to remove. That was it. That's all that he had to do was just remove the flooring, and he did so. And it was even stated during the trial that the Tabachnicks had no issue with what my client did. And in fact, it's the court didn't err in finding for Nolet in the indemnification claim. All of the issues that are presented in this appeal are clearly connected solely to CT Corp and their conduct. They contracted with the Tabachnicks. They did not provide the correct windows. They did not do what they...
What about the allegation that the windows were not replaced or not put into the home properly?
That was actually at trial. That was stated that my client approached CT Corp in regards to this and addressed the issue with CT Corp. And that issue fell on deaf ears. and he was told to put in the windows.
With the padding, et cetera, because they didn't exactly fit.
Correct. And he did what he was told to do, as a subcontractor to a general contractor would normally do. So in this situation, the issues here, the argument, the CT Corp's argument against Mr. Nolet fails, as the issues pertained in the appellant's argument solely rest upon them. The issue of the window installation took place by the appellant's improper measurements, improper purchases, and inexplicable failures to obtain proper permitting. And Mr. Nolet had nothing to do with this.
Okay.
Thank you. I yield the rest of my time.
No further questions. Thank you very much. Thank you all for your arguments. We'll take the case under advisement. Court will stand in recess.
Court all rise, please.